one would be a presentation from Zambia. I'll be guided by the SG, maybe the members, whether will present and then interrogate each presentation. So I'm gonna begin now with the Eswatini presentation. Before I start, honorable members, may I bring to your attention the fact that these processes are influenced by first of all, the parliamentary systems that operate in each and every country. It could be a unicameral parliament or a bicameral parliament, which in our case, we have a bicameral parliament, meaning we have two houses of parliament, the House of Assembly and the Senate. And I know in South Africa, they only have one, which is the National Assembly, and maybe in other countries, you have the same. Also, the other thing that influences the systems is the legal systems that operate in a country, namely either common English or common law, or the Roman Dutch common law. And in our case, in Eswatini, we inherited the Roman Dutch common law, and most of our laws are influenced by the Roman Dutch common law. So our common law is not homegrown. Of course, we do have statutory law, but most of the common law is the inherited one. And then the political systems can also influence the treaty systems. In our case, we have the monarchical system, where we have the king, who is the head of state. And then in other systems, there could be the presidential system. And for the treaty law systems, honorable members will note that there's two systems that operate in the different countries, namely the monist and the dualist system. Monism implies that the treaties that are entered into by countries apply automatically upon. Where are you? I'm still doing the introduction. That means the treaties apply automatically in those countries without having to be enacted into the domestic law. In our case, we have the dualist system, where the treaties, international instruments, and conventions have to undergo two processes. That is the international, which is the signing of the treaty, and then the ratification, which has to be done through an act of parliament, and has to have a 2/3 majority for it to be adopted or to be ratified and be considered to be part of the law. I will now proceed to the presentation. May we have the first slide, please? treaty making power in our system, we consider that it is between the two arms of government, which is the executive and the parliament, which is the legislative body. So this is in terms of the constitution, which provides or assigns power to negotiate and sign the treaties to the executive or which is the cabinet. And then it means that also, because I said that our system is a monarchical system, the treaty is signed in the name of the crown, which is the king. Then that is provided for in the constitution in our section 238(1). Next slide, please. So in terms of the constitution, we have 3 categories of treaties. That is the technical, administrative, and executive treaties, which are signed by the cabinet, and then they need to be tabled in parliament for adoption. Where the treaty doesn't fall in the 3 categories, it binds Eswatini only after it has been approved by resolution in parliament, as I've already alluded. Can you proceed? Next slide. The treaty process is as follows. In our jurisdiction, the treaty has to be signed, but the signing doesn't mean that the state is bound at that stage. The next step is ratification, and if ratification hasn't happened, then we can accede to the treaty to signify that the country is bound by that treaty. And then the next step is then the domestication, that is putting the treaty provisions into law through an enabling legislation. And I've already said that this has to happen through the parliament, and in our case, you will see how it's done because there are 2 houses. And then the last stage is the implementation, that is the application of the law once it has been gazetted. May we proceed? Proceed. No, please go back. I've already pointed out the fact that there are 2 instances for treaties in our case, the international intervention and then the domestic intervention. May we proceed? As I've already pointed out, these steps or processes are provided for in the Constitution, section 238. Subsection 3 provides for the technical, administrative, and those that are often executive nature. I'll make an example of technical treaty or technical international instrument. We have it is a regional instrument. We have the COMESA regulations, for instance, which countries are enjoined to apply in their countries, and for purposes of ensuring that they apply, each and every country has to go through the processes of making that international instrument to be part of their law. So in our case, like I've said, there are two processes. So the commercial regulations had to go through Parliament because they couldn't be considered to be part of the law because of the system that obtains. But in other countries, those regulations were applicable automatically. Also, I've pointed out that ratification in our case has to occur in the two, has to take place in a joint sitting of the two houses of parliament. And the constitution provides that there has to be a 2/3 majority of the members in the joint sitting for a treaty to be considered to be ratified. So the votes have to be 2/3. Then that treaty would be considered as ratified and therefore has to be enacted into the national law. My colleague will go deeper into the self-executing treaties because for my part, the Eswatini uses the dualist system. So let us proceed. Yes, there are role players that are supposed to ensure that treaties are implemented at the end of the day, starting from the signing up to the enactment of the law. In our case, I've already pointed out that there's the executive that has to sign the treaty at the international level. And then in country, the Attorney General has to have sight of that treaty and advise accordingly. Or the Attorney General can draft the documents that are required for purposes of ensuring that the treaty is enacted into law. Section 77(5) provides, for instance, that the Attorney General draws or peruses the agreements or the contracts or treaties or conventions or documents, or by whatever name they are called. It could be protocols, as we are considering protocols in this meeting. And then after advising on the provisions, then the treaty can proceed to the next step. Can we proceed? Can we proceed? Then there is another role player, that is the technocrats that are involved at the signing of the treaty. They have to come back to Eswatini, prepare a cabinet paper for the approval of cabinet. And that cabinet paper has to contain certain things for purposes of cabinet to consider and give their approval or for the treaty to proceed to the next step. Can we proceed to the contents of the cabinet paper? The cabinet paper has to indicate what decision is required of the cabinet on the treaty, agreement, or convention. It also has to explain the contents of the treaty or agreement or convention, sort of giving the background information on the treaty. The cabinet paper also has to give the cabinet information on the benefits of proceeding with the treaty, which has been signed or which is intended to be ratified. May we proceed? It should also spell out the obligations that the government is expected to honor, and that it has to say that the Attorney General has been consulted and has given his advice. It should also state whether there will be a need for amendment to existing legislation or whether there should be a new legislation to be put in place for the treaty to be given effect into the national law. The cabinet paper should also specify whether there is need for the country to make any reservations on the treaty. We know that there is a window for countries to opt out of certain provisions of a treaty for reasons that the country believe they need to opt out of that treaty. And also the cabinet paper has to contain information which is relevant to arrive at a decision that is requested of cabinet. Any other information, for instance, whether the treaty has any requirements that will need the country's resources, or that will need any other intervention that government has to be prepared for. Can we continue? Then the cabinet paper has to be submitted under the signature of the minister or the ministers where there is joint sponsorship to ensure authenticity. We know that the subjects of a treaty will determine which minister is responsible for submitting it to cabinet. So you will note that now there is a minister as a role player in the treaty process. If it's international trade, then the Minister of Trade. If it's gender issues, the minister responsible for gender. If it's agricultural related, then the Minister of Agriculture and so forth. May we proceed? Cabinet considers the cabinet paper and then gives its approval. Where ratification of the treaty requires that it has to go through Parliament, the sponsoring ministry then has to prepare whatever documents that are needed for the next process, which is taking the international instrument to Parliament. May we proceed? Where there is need to put it in a bill form, for instance, where a treaty has to have provisions within a bill, instead of having the treaty attached to the bill, then that instrument has to be prepared. You know, some of the treaties, when you are doing legislative drafting, you just have to attach them in a bill. And some of them you have to put the specific provisions within a bill. So it depends on the way the Attorney General or the legislative drafters see that the bill should take what format. May we proceed? Yes, I've alluded to the fact that some of the treaties have to go through Parliament for approval by the 2/3 majority. So in that case, then the bill has to be, the treaty has to be tabled in Parliament and then follow the processes which lead up to the constitution of the joint sitting, where the treaty will then be tabled, or a report by a committee has to be tabled in Parliament and adopted, following which then the treaty itself has to be tabled in Parliament, just like a bill, for purposes of the two houses to effect the ratification on that treaty. And it has to have the 2/3 majority of the joint two houses of Parliament for it to pass. May we continue? May you continue? All of those processes, then you will note that there is a speaker involved who has to ensure that the bill is brought before Parliament. And I'm not going to go into the processes in Parliament, because we're all aware that the documents, a bill or a treaty, they have to be submitted to Parliament, and there are processes of bringing that document into Parliament for the members to consider it and then pass it into law. So we note that there are players, being the speaker, who's doing the administrative work. Of course, there are also officers involved, the legal clerks, the committee clerks, and so on. And then there is the parliamentarians themselves. First, the committee on that particular subject matter. If it's trade, the committee on the Ministry of Trade. If it's a criminal related treaty, for instance, the money laundering treaties, then the Ministry of Justice has to be involved for ensuring that the treaty comes through Parliament until the end of the processes. Of course, also, I mentioned that the Minister of Foreign Affairs, in most cases, has to be involved, because they are the ones who know how to attend to international issues, and also the ones who at the end of the day, the treaty has to be submitted to for purposes of ensuring that the treaty body at the end of the day is advised that Eswatini has ratified, and here is the instrument of ratification. So the Foreign Affairs Minister is another role player, and the Foreign Affairs technocrats are role players as well. May we please proceed? Proceed. Well, at the end of the day, like I said, the Foreign Affairs Ministry knows where to deposit instruments of ratification. In terms of international law, under the Vienna Convention on the Law of Treaties, all countries are obliged to register ratification with the Secretariat of the United Nations, and this applies to United Nations treaties. Also, where there are secretariats for different treaties, for example, in environmental treaties and environmental protection treaties, we know that most of the treaties have secretariats who or which administer those treaties, and for purposes of reporting and so forth and so forth. So the technocrats have to ensure that the Minister of Foreign Affairs is advised that for this particular treaty, there is a secretariat which is supposed to be advised on the ratification and for purposes of reporting. Even I believe in under SADC, the secretariat has to be advised by the Minister of Foreign Affairs that these protocols which were ratified on such and such a day, these are the instruments and so on, and whether domestication is underway or has taken place. May we proceed? May we proceed? I am now going to go to the challenges and bottlenecks that we have identified in the processes that I've already laid before the committee. First of all, what we noted is that there's no dedicated department or unit for international instruments in the Office of the Attorney General. There is a department which is called Agreements and Contracts Department, but the way it considers a lot of bilateral instruments than international instruments. So you find that it's not really, you can't say it's a department that is fully fledged for considering international law treaties. And also there is a recently established party reporting unit, which to me only comes at the tail end of the process, because they only come in to assist the ministries and departments on how to report on particular international instruments. And on consulting the officer there's one officer who is an attorney in that department. On consulting her, she did say that they are not involved at the signing. They are not involved through the other processes. They only come in to assist for the reporting purposes. So I think there's a problem there, because then they'll have to, if they are not advised by these ministries, it's only when reporting has to happen that that office will say, Ministry X, you have to report what is happening. or if the ministry is proactive, it will approach that unit to say, please assist us on reporting. So that to me is a challenge which I've identified. Also, there are no laid down guidelines or flow processes for ratification and domestication to guide the role players, the executive, the technocrats, foreign affairs, attorney general, parliament, and then in our case, the King's office, because at the end of the day, the King's office has to take the instruments that pass through parliament. They have to take the instruments to the king to explain to the king what this is all about. Although, of course, at the beginning, you will find that the king was there to sign, like it has happened in the protocols. The king was there to sign some of the protocols that were signed in the last 2 weeks. But then at the end of the day, now the treaty comes in the form of a legislation. So there has to be explanation to the king what is happening for purposes of appending his signature. In terms of the constitution, the king, our legislation is enacted by the king and parliament, or king in parliament. May we proceed? Technocrats do not involve the Office of the Attorney General and Legislative Drafting Department at the negotiation and ratification, at the negotiation stages and the signing stages, not the ratification stages, because then at that stage, they will then involve the office. So the fact that they are left out and they are only engaged in the middle or at the end, it's not a good thing, because the Office of the Attorney General has to advise on the provisions of the treaty and the processes that have to take place. Because in most cases, you find that nobody knows what has to happen when there's rushing to enact a certain or to push forward a certain treaty, just because maybe there is an emergency or there has to be a meeting in the near future. So now everybody's running around, nobody's knowing what to do. May we proceed? Also, the role players that need to be capacitated on what is happening with treaties is the parliamentarians, because you find that they will be aware of how to do their legislative mandate in as far as national law is concerned. But then in as far as international treaties are concerned, then you will find that maybe they are not really aware of the processes. So they have to be oriented on the two aspects of legislation, the national and the international, and the obligations that come in the ratification, in the signing, ratification, and the domestication of the international instrument. So this is one particular aspect to which the legal clerks in Eswatini have decided that since we are going to be ushering in a new parliament, the parliamentarians have to be capacitated on international law and international treaties, conventions, and the processes that are involved. So also, the question of why the slow pace in ratification Sometimes you find that the signing is done, but then the treaty or the contents thereof are not a priority for that particular line ministry. Or if it's not a priority, it's not like maybe it's not, it's a matter of the resources not being available, or the capacity, or whatever processes that have to be put in place before the treaty can be applicable. So you find that that would stall the process. Next, challenges also. Yes, I've talked I've spoken about the challenges relating to the logistics not being in place. The time, the money, the budgeting, and so forth. So all that is one particular challenge that I see. Also, the foreign affairs personnel, both the administrative staff and the technocrats, in most cases are not on board on what has to happen. I've already alluded to this. And they have then to be capacitated, and they have to be taken through what the provisions of the Constitution provide. The Section 238 of the Constitution, because I've heard from the officer in the agreement section, she lamented that at times the foreign affairs come to them to ask, is this a self-executing treaty? Is it a treaty that needs to go through Parliament? So now, even the ministry that was involved in the beginning is not advising foreign affairs appropriately. And then foreign affairs is also asking the legislative drafters, or asking the officers in the Attorney General's office who do not even have the background of the treaty. So in that instance, there is need to be coordination from the beginning, so that everybody is on board. Next slide, please. There are recommendations that we want to put forward for ensuring that the challenges that I've already pointed out and bottlenecks are attended to. Maybe there's a need to have a fully fledged unit that coordinates international instruments from negotiation stage to the last end, where the treaty instruments are deposited. In other countries, I think in South Africa, in the office of the Attorney General, or the head of the principal advisor to government, I don't know what they call the principal legal advisor, but I heard from a colleague that they have a department that is dedicated for international instruments. Also, we need to develop guidelines for the domestication, or for ratification and domestication of treaties under our dualist system, so that we know the processes from A to Z. Next slide. Also, there's need to capacitate all role players in the processes. And also the Attorney General's office should also be informed by the role players who attend to the signing, negotiation, and so on and so forth. They have to be informed that there's a treaty which the Attorney General has to consider at a certain stage, and they have to be advised on what the treaty contains so that they can decide whether the treaty is self-executing or it is not. Also, there's the need to, like I said, to capacitate members of parliament on their role and how they can ensure ratification and domestication as they carry out their mandate. Also, may I add that we know that the execution of treaties is the mandate of the cabinet, but also parliament can, in their oversight role, ensure that a particular treaty which they are aware that it has been signed, they can, like the Secretary General said, they can bring resolutions to parliament. So the MPs have to be capacitated on how to do that and how to follow through the treaties. The compendium, for instance, would be one document that helps. Of course, it needs to be updated for going forward, so that members of parliament know that there are these treaties that need to go through this stage up to the end of the line for purposes of ensuring that the country adheres to the obligations in under that treaty. Next slide. Is that the end? Thank you so much. That would be the end.
Yeah, thank you very much, Ms. Toko. Honourable members, I would beg to be guided. Do we let the whole presenters present and then we ask questions in the end, or we do presentation and we ask questions? I stand to be guided. Yes, Madam Vice Chair.
Thank you very much, Honorable Chair. I think we should receive all the presentations and then you jot down whatever you want to learn after to be discussed. I mean, if you may accept that.
Any other comments from that side? Yes, you have the floor.
Morning. I think we're in agreement with what Honorable Charlie says. We listen to all the presentation and then we take the question at the end.
All right, Madam Secretary General.
Yeah, without going against the grain, I hope we are noting that these are different systems. And it would have helped for you to zero in into what Eswatini, being a monarchical system, has unique features and how they do things, so that we don't receive them as if they are one or the same thing. And there was deliberateness in doing that, so that we appreciate, when you look at the data, why other countries are ahead and why others are behind. We deliberately arranged that Angola then comes in between, then Zambia, because it's more or less the same, should come to the end. So each country has a different system, unless but the wisdom of the members may prevail. We'll bow to that.
No, I mean, SG, I was just thinking maybe there are things that will overlap in all the presentation. Maybe, I don't know.
Yeah, I
stand
think
corrected.
I think within the three presentations, we're also going to find some similarities and differences that we can do some comparisons. So the best would be that maybe for the first presentation, we jot down the notes. The second one, we jot down the notes, and then we're going to have the whole comparison at the end. because they, of course, they differ, but they should also have some similarities in them. So our presenter from Angola, you have the floor.
Muito obrigado. Not yet.
Mr. Chair, just wanted to,
Yes, Honorable.
I wanted to clarify before Angola start the presentation. Was this presentation shared with us on the portal, no? Because
Which presentation? The one from
for
Eswatini?
Angola,
No, I don't think so. But you can share. Ronald can share.
When was it shared? Because if it was shared recently, it's not translated, so it can be shared.
Yeah, but it is in Portuguese and in English.
Okay, then that solves the problem. Ronald, kindly share the presentation with members. Thank you. It's in English, I'm advised.
The English translation may not be so well, but anyway, you will have a feeling.
May I
Proceed,
proceed, please?
Chair.
Proceed.
Bom dia, muito bom dia, Sr. Presidente. Bom dia, senhores deputados. De facto, depois de ter ouvido a apresentação da minha colega, dou-vos completa razão que há aqui muitas similaridades na abordagem e justamente por isso eu tive também de refazer partes da minha intervenção no sentido de evitar repetições. Eu falarei sobre um bocado sobre os sistemas de aprovação de tratados. Isso já foi abordado também pela minha colega, mas tentarei evitar repetições. Depois falarei também sobre as leis modelo, que é o assunto que nos traz cá, e tentarei abordar se de facto essas leis modelos são um tratado propriamente dito ou são as considerados soft laws. E a parte que mais me interessa é sobretudo apresentar aos senhores deputados qual é a situação da implementação das leis modelo em Angola. Também concluirei na parte final com algumas recomendações. Este é o menu que eu tenho para apresentar-vos. Relativamente aos sistemas de aprovação de tratados, a minha colega falou exaustivamente sobre eles, mas penso que todos os senhores deputados já sabem que um tratado é hoje a principal avenida para que os Estados e os demais sujeitos de direito internacional possam contrair direitos e obrigações. Isso é feito por via de tratados internacionais. É verdade que os tratados não são a principal fonte de direito internacional, mas é a rota mais usada para contrair obrigações no plano internacional. E os tratados, como todos nós sabemos, são acordos de vontades entre Estados e outros sujeitos de direito internacional e que se destinam a produzir efeitos jurídicos. Os tratados obedecem uma tramitação, um processo próprio, e a oradora que me precedeu já falou destas fases do processo de conclusão de tratados. Nós podemos resumir todas essas fases em três fases. Uma fase de negociação do tratado, uma fase de assinatura e, finalmente, uma terceira fase de vinculação ao tratado. E isso pode ser feito ou por via da ratificação ou por via da adesão, accession. Vamos encontrar estas três fases em todos os nossos estados. O processo de conclusão de tratados passa por essas fases. E a minha colega fez aqui alusão à Convenção de Viena sobre os direito dos tratados, que cuida dessa matéria, de 1969. Agora, os sistemas de aprovação de tratados. Nós temos na nossa região 16 Estados-membros na SADC. Se estivermos a falar em fórum parlamentar da SADC, penso que somos 15 Estados, de 15 parlamentos-membros. E olhando para os 16 Estados-membros da SADC, ou para todos os Estados-membros das Nações Unidas, nós vamos encontrar três sistemas de ratificação de tratados. Ou um sistema em que a ratificação de tratados é uma competência do Executivo, é o titular do Poder Executivo quem ratifica os tratados, ou vamos encontrar um sistema em que esta é uma competência do Legislativo. Já foi assim em Angola, na chamada Primeira República, era o Parlamento quem ratificava os tratados. Ou, por último, vamos encontrar um sistema misto, que é o que estivemos a ver aqui há bocado, vigora também em Swatini, em que a ratificação é uma competência partilhada pelo Executivo e pelo Parlamento. Este também é o sistema que existe em Angola desde a aprovação em 2010 da nova Constituição. O Executivo negocia os tratados ditos solenes, negocia os tratados, assina-os, remete a Assembleia ao Parlamento para aprovação, o Parlamento aprova-os por via de uma resolução, tal como vimos há bocado em Swatini, e este tratado é depois remetido ao Presidente da República, que é o titular ou o chefe do Poder Executivo, que vai ratificar esse tratado. Ratificar em alguns casos, noutros casos trata-se de adesão, dependendo do facto do tratado estar em vigor ou não. Portanto, esses são os sistemas de ratificação de tratados que existem nos nossos estados. Cada um dos nossos estados enquadra-se, obviamente, num desses sistemas. A minha colega, na sua apresentação, falou sobretudo dos tratados. E uma questão que nós devemos aqui, talvez, refletir, é saber se as nossas leis modelo fazem parte daquilo que... Qual é a sua natureza? São hard law ou são soft law? São instrumentos jurídicos verdadeiramente vinculativos que criam direitos e obrigações para os Estados, sendo hard law, ou são meras recomendações, meros padrões de atuação considerados desejáveis e que devem ser seguidos pelos Estados, embora sem caráter de obrigatoriedade. E aqui nós devemos dizer que, na verdade, as leis modelos fazem parte daquilo que nós designamos por soft law no direito internacional. Um conjunto de normas incitativas, normas que não são vinculativas, que contêm um padrão de atuação que é considerado desejável, mas nem por isso elas deixam de ser importantes. Por isso é que nós devemos distinguir entre harmonização legislativa e unificação legislativa. O chamado soft law, como é o caso das nossas leis modelos, são, no fundo, um instrumento, uma técnica legislativa que tem como objetivo fazer com que os seus destinatários harmonizem o seu quadro legislativo em vários setores. E é justamente por isso que nós já temos aprovado pelo Fórum Parlamentar da SADC 5 leis modelos. Eu, às vezes, ouço falar em leis modelo da SADC. Eu tenho dúvida se são mesmo leis modelos da SADC ou são leis modelos do Fórum Parlamentar da SADC. Penso que são do Fórum Parlamentar da SADC e não da SADC. Como todos sabemos, ainda estamos num processo de luta para nos transformarmos num verdadeiro órgão da SADC. Mais correto falar em leis modelos do Fórum Parlamentar da SADC. E o que se pretende com essas leis modelos é a harmonização legislativa em vários setores. Harmonização não significa unificação. Na harmonização, os Estados podem não ter uniformidade legislativa. É o que nós temos no direito tradicional africano. Em todos os nossos países, nós temos o Instituto da Lobolo, o alambamento. Todos, aqui uma harmonização. No nosso direito tradicional, vamos encontrar isso. Mas não há, entretanto, unificação, porque mesmo o Lobolo, na sua prática, conhece diferenças aqui e acolá. O valor do dote pode ser diferente. Quer dizer, é harmonização e não unificação. Mas a harmonização tem como objetivo final a unificação. Quer dizer que, por via da harmonização legislativa, nós, mais tarde, vamos alcançar essa unificação legislativa. Portanto, é bom clarificar isso, porque, por vezes, fica-se com a impressão de que o que se pretende com a lei modelo é unificação, quando não é bem assim, penso. Bem, indo para o caso concreto de Angola, temos a lei modelo sobre a violência baseada no género. E, em relação a isso, a senhora secretária-geral dizia ontem que alguns estados alegam que já têm um quadro legislativo próprio sobre cada uma destas matérias que é tratada por estas leis modelo. É, de facto, o que acontece também em Angola. Em relação à violência baseada no género, em 2011, o Parlamento aprovou uma lei sobre a violência doméstica. Portanto, estamos a falar de uma lei aprovada antes da aprovação da lei modelo. Mas temos de reconhecer que essa lei aprovada em 2011 diz menos do que aquilo que diz a lei modelo sobre a violência baseada no género. Logo, aqui o desafio de se rever esta lei no sentido de adaptá-la ao contexto atual. E, nesse sentido, os deputados são conscientes da necessidade de, a quando da revisão dessa legislação, se ter em conta as boas práticas que vêm refletidas nesta lei sobre a violência baseada no género. Temos também a lei sobre eleições, lei modelo sobre eleições. Esta lei é de 2018, mas e foi também, olhando para ela, foi inspirada, de algum modo, nas normas e padrões sobre eleições na região da SADC. Foram adotadas em 2001 e todos nós sabemos que essas normas foram um primeiro instrumento, não apenas regional, mas também continental, sobre esta matéria. E estas normas influenciaram a legislação eleitoral angolana. Embora tenham também o caráter de soft law, quando o legislador angolano aprovou a nossa legislação eleitoral, teve-se também em devida conta o disposto nestas normas e padrões. Recentemente, foi aprovada em 2021, em preparação para as últimas eleições que ocorreram em agosto do ano passado, foi aprovada a alteração à Lei Orgânica das Eleições Gerais. E nesse exercício de alteração desta Lei Orgânica das Eleições Gerais, houve o cuidado por parte de todos os atores políticos terem em conta a lei modelo sobre eleições. E isto foi interessante e agradável de se constatar, quer o partido no poder, quer os partidos na oposição, várias vezes, nos seus argumentos, fizeram menção a esta lei modelo sobre eleições. Não significa, entretanto, que o novo quadro legislativo está completamente ou totalmente conforme a lei modelo sobre eleições. Porque há aspectos que ficaram de fora, mas, entretanto, é agradável notar que algumas disposições da lei modelo foram acolhidas. Só para dar-vos um exemplo, no anterior quadro legislativo, nós não tínhamos um prazo fixo para realizar eleições. E, fruto da boa experiência desta lei modelo sobre eleições, a nova lei já fixa um período para realizar eleições. Portanto, é apenas um dos vários exemplos que eu podia dar. Um dos exemplos que eu podia dar. Temos também a lei modelo sobre HIV e SIDA. E devemos dizer que muito antes da aprovação desta lei modelo, em 2004, o Parlamento já havia aprovado uma lei sobre o VIH e SIDA. E isto também muito como resultado do bom trabalho que o Fórum Parlamentar da SADC vinha fazendo neste domínio da prevenção e combate do VIH e SIDA. Este foi sempre um dos projetos do Fórum Parlamentar da SADC. A própria secretária-geral, na altura, era responsável por este programa e o ativismo do Fórum Parlamentar da SADC nessa área levou que nós também tivéssemos de aprovar esta lei sobre o VIH e SIDA. Mais do que isso, antes, em 2003, a nível presidencial, foi também aprovado um regulamento sobre o VIH e SIDA no local de trabalho, para questões de natureza laboral. Mas estes dois instrumentos, claramente que hoje já estão ultrapassados, Por isso é que, em 2021, foi aprovado um novo Código Penal e este novo Código Penal já trata de algumas matérias relativas ao VIH-Sida de uma forma mais moderna e inclusive agrava as penas resultantes de condutas que são consideradas criminosas, como o contágio doloso, a discriminação por razões ligadas ao VIH-Sida, estigmatização, etc. Mas, obviamente, que o Código Penal é um instrumento generalista. O que se precisa agora é rever a lei sobre o VIH-Sida no sentido de atualizá-la, e quando isso for feito, há aqui um bom paradigma que é a lei modelo sobre o VIH-Sida. Quanto à lei modelo sobre a erradicação do casamento infantil, devemos dizer que a própria Constituição já confere uma proteção especial à criança. Diz isso claramente a Constituição. Mais do que isso, em 2012, foi aprovada uma lei sobre a proteção e desenvolvimento integral da criança, que contém um conjunto de disposições que condenam as práticas como o casamento infantil. São práticas que existem, embora o nosso Código de Família, aprovado em 2018, diga que o casamento só é permitido em regra atingida a maioridade, que no nosso caso é de 18 anos. Infelizmente, ainda existem algumas partes do país estas práticas de casamento infantil, contrariando, inclusive, aquilo que vem disposto não apenas na lei angolana, mas também em relevantes instrumentos internacionais do que o Estado angolano é parte, como é a Convenção sobre o Bem-Estar da Criança, a Convenção Africana, convenções das Nações Unidas sobre os Direitos da Criança, etc., etc., que são instrumentos internacionais que foram, de que Angola é parte. Portanto, a lei modelo oferece-nos uma valiosa ferramenta para rever o nosso quadro legislativo sobre essa matéria. A título de conclusão e recomendação, eu penso que não há dúvidas que, embora as leis modelos sejam consideradas como soft law, ainda assim são extremamente valiosas para a pretendida harmonização legislativa ao nível da nossa região, numa primeira fase, e numa segunda fase, a tal unificação. E se assim alcançarmos esse objetivo, claramente que isso facilitará o nosso processo de integração regional. É preciso, obviamente, ao nível dos parlamentos, haver consensos quanto a um amplo consenso, sobretudo, um amplo consenso sobre a aplicação dos postulados destas leis modelos. Às vezes isso não é possível, pela natureza, nem sempre é possível, pela natureza dos parlamentos, com várias formações políticas, mas é sempre importante procurar obter consenso. E não devíamos ser reféns apenas dos atores políticos, envolver também a chamada sociedade civil. Temos um conjunto de organizações da sociedade civil trabalhando no domínio do VIH-Sida, da prevenção de casamentos precoces, em várias áreas. E essas organizações, às vezes, fruto do seu trabalho, pressionam a classe política a adotar estas leis modelos como boas práticas, sobretudo. E se calhar, deixaríamos como recomendação que houvesse uma maior participação do executivo na abordagem destes assuntos, mesmo ao nível do Fórum Parlamentar da SADC. Há sempre, por vezes, a tendência de nós, enquanto digo nós, Fórum Parlamentar da SADC, reunirmos apenas como estrutura parlamentar e depois passar tudo para o executivo, para efeitos de implementação. Eu percebo que há aqui uma separação de poderes, mas acredito que se na abordagem de alguns desses temas existisse já também algum envolvimento de membros do executivo, dos relevantes departamentos ministeriais do executivo, talvez isso pudesse facilitar o processo de implementação dessas leis modelos a nível nacional. Senhores deputados, senhor presidente, esta é a minha contribuição para este debate que vamos ter aqui e muito obrigado.
Thank you very much, Mario, and I think we're going to move on to the next presenter from our legal team from Zambia. You have the floor. Please use on your mic so that the handset can capture.
You have not been there. No. They are one of the greatest. I want to be there today. Today. Thank you.
Thank you.
I've never seen one like that.
So can we move for me?
This is the time I'm doing.
When will be there?
Because I was not getting it in the car. So when you get this, it's wow.
So I can use that.
That's not good. I'm getting a whole thing. He knows the answer later. Unless she's trying to get out of the room. But I'm not the woman. I know.
Just- Is this one? Oh, this one here.
Yeah.
Yes, please, you have the floor.
Members. So the next presentation basically is specific to Zambia as a jurisdiction, but most of the other former English colonies and common law countries can relate. Malawi, Botswana, Zimbabwe have similar systems that can be used. So the starting point for me is, first of all, the disclaimer. So this paper does not represent the position of the Republic of Zambia or its commitments to the international community, but is based on the interpretation of the law, knowledge of government processes, skills, and training of the author, and his considered view on the subject matter. So what we're going to share basically is the Zambian situation. And I'm hoping that this paper and some of the information that we're going to share will be used by the SADC-PF for their interventions with regard to Zambia. What is very clear from the presentations we've had is that I think some of the approaches should be very country specific because of our different systems as we have established. So with a certain common areas that have already been captured, I just wanted to highlight, first of all, the fact that ratification and domestication are a very, very important function of the government of the Republic of Zambia. So we are a common law country, a former British colony. So we have certain processes that are similar amongst most of the SADC members. So the presentation will first of all outline the process of ratification and domestication of international agreements under Zambian law, and we'll zero in on how these also relate to SADC protocols and some of the interventions that could be done to expedite the ratification and consequently the domestication of the SADC protocols. So the second position will be the challenges and the bottlenecks, which I think is the elephant in the room, how we should deal with these. And this will be specific to Zambia, but some of the solutions that are provided may cut across the other countries, and that is something that is food for thought for the members at the end of the process. Then, of course, we'll make recommendations for measures that could be undertaken to expedite the ratification and domestication of SADC protocols. So I'll be speaking specific to Zambia, but most of these interventions are actually cross-cutting. So other countries can basically be able to use the same interventions. Okay, so we're a dualist nation, which means that once we've made a commitment at international level, the provisions of an international agreement do not apply to our country automatically. They have to go through an established procedure in that regard. So the two most important legislation in our country which govern ratification and domestication are the Constitution, which empowers Cabinet to recommend the ratification of international agreements to the National Assembly, and the National Assembly approves them before they are acceded to or ratified. So basically, the oversight function of Parliament comes in on a function which is on the executive, that is the ratification of international instruments. So the Constitution is the starting point, and then we have a very elaborate procedure under the Ratification of International Agreements Act. Now, as you may be aware, in 2016, Zambia went through major reforms in terms of the Constitution. And it is on the basis of the Constitution that all other laws have basically conformed to some of the things that are covered there. And then that is why I think at some point, maybe the SADC-PF can actually carry out an audit of the laws of Zambia and check how much they conform with some of the model laws that have been put in place. You will find out that we've made a lot of strides in some areas and we're lagging behind in others. The understanding is that the model laws also provide for minimum standards. It could be that we could have outdone ourselves in certain areas, and there's still more areas where we need to do a bit more work. So the starting point in the process of ratification is that at international level, once the agreements have been agreed by the country, or how we would call it in principle, there's a process then that has to happen internally for you to realize the provisions of a particular international agreement. So the starting point is we need to identify two types of ministers. One is the minister responsible for a subject matter and a minister responsible for foreign affairs. These are very two key players in the ratification process. So the starting point or the first consideration for an international agreement is what I have termed the best interest test. So the minister responsible for a subject matter considers whether it's in the best interest of the state to ratify an international agreement and considers its objects and also whether existing legislation already provides for what that international instrument contains, the impact of implementing any measure specified in the international agreement, and then any legislative measures that may be required to give effect to the international agreement. Now, obviously, after the ministers fly back from this international agreement, they have to engage technocrats to make such a determination. And then once that has been done, and once the best interest test has been passed, and the minister responsible for that subject matter has satisfied himself that indeed this would be in the best interest of the country if the international instrument was ratified, then the minister will consult the Attorney General, and so that they initiate the process of ratification. Now, why consult the Attorney General? The Attorney General is the principal legal advisor to the government and sits in the Ministry of Justice. The Ministry of Justice is where the legislative drafting unit is, as well as the international law and agreements department. So those sit with the Ministry of Justice, and the Attorney General basically is under that ministry. So first step, best interest test. Once the best interest test has been passed, they will now move to the next phase. So the minister in charge of the subject matter will then prepare a cabinet memorandum seeking approval in principle. Now, why approval in principle? Because it's not the role of the executive to approve an international instrument. So they agree in principle to the proposal to ratify an international agreement. So cabinet memorandum outlines the national interest aspect, which is a very, very important one. I'll refer to it later in my presentation, because what comes out of international instruments is what is considered at international level, but all those have to be wedged or checked against the national interest and see if the two are in consonance. Also, what will be required to implement, meaning what do you have to set up? What is the financial implication of having to put all these measures in place? So all that has to be looked at. Financial implications, very, very important. As the Bible says, money answereth all. It's the same with administration. Without money, you can literally do nothing. So they always have to look at that financial implication of going ahead. Then also reservations. Does the international instrument provide for reservations? And I'll touch on this subject also, because I think I'll be making an accusation to countries that the moment they're uncomfortable about one aspect of an international agreement, they don't ratify the whole agreement, whereby it will be advisable if you know that there's a problem somewhere, and you can enter a reservation, you enter that reservation, and in principle, basically ratify the rest of the international agreement. So second part, cabinet memorandum, then cabinet approves in principle. So at this point, cabinet will sit. This is the third point, and consider the memorandum. Does it take care of all the interests of the government? And once that is done, and approval is done in principle at cabinet level, still in the executive, we haven't yet crossed over. At that point, once it's approved, the vice president, who's the leader of government business in parliament, will then submit a proposal to the National Assembly to approve the international agreement before that international agreement is acceded to or ratified. So the next process is now approval within the National Assembly. And I think I was just trying to explain that we have some agreements relating to SADC that have actually come through to Parliament. So those should be dealt with in the next session of the next meeting, which also marks the first session of Parliament. So the normal processes of Parliament go through, are undertaken. First thing, the Vice President will present the international agreement for approval. The Speaker will then send it to an appropriate committee, depending on the subject matter. That committee will then begin to consider that international instrument. And once Parliament has considered it, now in terms of the internal processes, they're very similar to the other parliament. So you have a committee seat, call stakeholders and witnesses, produce a report, present the report to the House. The House resolves, the report is adopted. And if it's positive, it means at that point, the Parliament or the National Assembly has ratified that international agreement. So, or the proposal for ratification of the international agreement. So once that is done, it means the executive is now free to proceed with the other processes. So the other processes basically is that once approval is done, the minister responsible for foreign affairs is the one reported with the power to deal with international agreements. They'll prepare an instrument of ratification. After the instrument of ratification has been done, which may or may not include reservations. The minister deposits the instrument of ratification in a depository in the manner designated by the international agreement or negotiating state. So this is specific to what that international agreement provides. So Ministry of Foreign Affairs then takes care of that part. There is an instrument of ratification. An original copy of the instrument is kept at a registry, and the registry, by the way, is located at the Ministry of Foreign Affairs. So the implication of this we'll get to see in some of the recommendations we'll be making. So this sits with the Ministry of Foreign Affairs, and then a copy is sent to the ministry responsible for justice. Now, at this point, when it has been sent to the Ministry of Justice, they just keep it for their own record, because it's not automatic that once an international instrument has been ratified, it will immediately be domesticated. So a copy is kept by the ministry in charge of foreign affairs, and then a copy sent to the Ministry of Justice. And then at that point, we say that the international instrument has been ratified. So this is just one step out of what we want. The most important, in my view, is the domestication, because you can have all these beautiful laws at international level. If they cannot be applied locally, they don't mean anything. So you have these floral statutes, international instruments, but if there are no benefits that accrue to the citizens of the country, then there's really no work, which is why, as members of parliament, you are very important in making sure that all the laws and all the good model laws that come up are then somehow realized in terms of domestic legislation. So there are 5 processes, as you've seen, at least for the ratification process, which involve the executive arm and also the legislative arm, which in this case is performing an oversight function. So all this part is oversight. The next stage, which we are going to be looking at, is now the issue of the domestication process. And this is really the show for the parliament, because you are the ones who are reposted with the powers to legislate. Now, the domestication process is also very elaborate, but unfortunately, it goes back again to starting with the minister in charge of the subject matter. So we're going back to the minister. Now, there's a reason why I've highlighted the minister in charge of the subject matter. So this is the same minister who started the process of ratification, and they're now in the next phase, and also have to initiate the process of domestication. So starting point is that the minister responsible for the subject matter will initially give instructions to the Ministry of Justice. Why? Because the legislative drafting department sits in the Ministry of Justice. And the Minister of Justice, the Minister of Justice, and indeed the Attorney General, being the principal legal advisor to the government, is the one who then undertakes the idea of now drafting that model international agreement into domestic law, at least the initial stages. So the ministry basically writes a letter to the Ministry of Justice indicating the fact that they wish to ratify, they wish to domesticate an international instrument that is involved with their mandate. At that point, the ministry now receives those instructions and begins to basically operate under the instructions of that particular ministry. So the ministry will also put explanatory notes for what they are trying to achieve, what amendments they want to make to the law, policy considerations. All those details are given to the Ministry of Justice, and in this case, the legislative drafting department. So the next stage is drafting of the bill, which, as we know, is still in the executive arm for now. I'll skip the parts for the legislature because they are similar, but I just wanted to emphasize what happens in the background with the executive before the documents find themselves before the National Assembly. So within the ministry, there are what you call internal legislative meetings and cabinet legislative meetings. So at this point, this is the first contact with the public over basically the consultation with the stakeholders. They will draft the bill based on the findings by looking at the ministries involved, the stakeholders, civil society, the churches, and all sectors of society. Those will come through and form part of the internal legislative meetings and give their input on some of these. I don't know if SADC PF would have a way of contributing to these consultative meetings at this point as a stakeholder, because they are free to do that. And that is something you may want to look into SG, where if there's a particular international instrument that has a bearing on our model laws, then it can be good to intervene at this point, so that you don't now start going to say, can you amend? You can be involved at the early stages of drafting of the bill. I think that is something that can happen. So after these technical meetings are done, there will be a complete draft done. And again, we come back to cabinet memorandum. Now, if you've noticed in our processes, we are now coming back to cabinet on basically the same subject matter. So part of our thinking should be, how do we streamline some of these processes? Because you're coming back basically to talk about the exact thing that had already gone through cabinet. So now this cabinet memo is different in that it's bringing up an actual bill drafted by the Ministry of Justice. So again, who brings it? It's the ministry responsible for the subject matter. That's the sponsoring ministry for the bill. So after cabinet has approved that bill, the bill is sent to the government printer for printing and gazetting and conveyed to the National Assembly for enactment. Usually the National Assembly will receive an advance copy or the government printer is printing so that they can start their processes. So it's quite swift. I can only attest to the fact that parliamentary processes are very efficient. I can't speak for the executive, but once the processes start within the parliamentary system, they are dealt with expeditiously. So the bill will be received by the National Assembly through Cabinet Office. Again, the Speaker refers the bill to a relevant committee for consideration. The committee considers the bill and receives submissions from relevant stakeholders, second part of consultations on the contents of the bill. So the committee reports to the House on the bill, and the bill goes through the various stages until assent by the President, signifying enactment of the bill into law. This also now is what we have said is the domestication. So at this point, it becomes enforceable law, implementable law, which can then be used by that country and benefit the citizens of that particular country, in this case of Zambia. Now, there's something that I thought we should touch on, and I noticed the other presenters had not touched on. The issue is, what method does domestication take? This is now a technical drafting issue. Now, international instruments use different language. The issues of, for drafters, we pay attention to issues of may, shall, what the commitment is, what is the effect of those words. So the ways indicated here are the various methods that drafters use to domesticate. So one easiest way is to get the entire international agreement and just put preliminary sections and attach it in the schedule, meaning you have domesticated that agreement in total. In my experience, my 11 years experience in Parliament, there's only been 1 or 2 international agreements that have been domesticated in that manner, simply because the countries have to customize the international instruments to fit their either drafting system or their statute books. So the first one is that it set out the international instrument in a schedule. That is the easiest method. The other one is setting out the salient provisions in the international agreement in the substantive part of the act, meaning you now come up with an act which specifically now deals with the provisions which have been borrowed or picked from the international agreement. The other one is rephrasing the terms in the international agreement. Why? Drafting styles are different depending on the jurisdiction. So you may need to customize it to fit your particular country. Adopting in an act the terms of the international agreement in its entirety, which is the example that I had given. I remember we had one for the Millennium Challenge, which is based on an agreement, an international agreement. That one we picked all of it, hook, line, and sinker. And that would be the most ideal. But like I said, it has to fit in within a particular statute. So domestication takes different forms. And because it takes different forms, this is part of where our problems begin. If an international instrument is passed, it's not automatic that that international instrument subject matter will just be for the responsibility of one ministry. It may cut across various ministries. So in that case, how are you going to ensure all the ministries have started the process of amending the law for the statutes that are basically relevant to them? I'll give a very good example. So when you are dealing with issues of gender, for instance, you may need, and this is very ideal for countries that have constitutions, you may need pronouncements within the constitution, which is what we did in 2016. So the SADC protocol on gender basically has been implemented to the extent that the Constitution now places an obligation on all appointment or all appointers to positions to ensure 50-50 gender representation. But at the same time, there might be need to pass the Gender Equality and Equity Act, which will now provide the framework for how to monitor the country's compliance. So those will sit in two different statutes. And by that, it may be two different ministries sponsoring many other bills. So this makes it very difficult, even for SADC-PF to know whether a country has properly domesticated. Why? Because it will be sitting in different laws. So later, as I will show in my recommendations, I'll provide a solution to this problem so that we have a more centralized system of getting information over the status of ratification. So you need to give the responsibility to a primary ministry, which will then collaborate with the other ministries. That's the only way you can have proper data over the standing of a particular country as far as ratifications are concerned. Now, based on what we've discussed and some of the hints that I could have given, we'll now get to the challenges and bottlenecks in ratifying, domesticating, and in this case, the SADC protocols, because now we are specific to what we want to achieve. First one, lack of timelines for ratification and domestication. Now, the most important timeline that is usually given in international agreements is the issue of when the international agreement will take effect. After how many signatures? Basically, that is the only time in my experience that I have seen that international instruments provide timeline. There are no timelines or obligations on states as to when they should ratify or domesticate. So what that simply means is it's done at the whims of a particular government or a particular ministry. They might have other priorities, so they will never really run through with the process. So the recommendation basically is that member states should be given a time frame within which to ratify a protocol and ensure that the laws of that member state are in conformity with the provisions of the protocol. Now, I had raised another issue. Most countries have silent reservations. I'll call them silent reservations. So they'll have a problem with a particular provision, but never get back to the treaty bodies to explain that, look, we have agreed in principle, but we have a problem with this. Is there a possibility of a reservation? That way, we'll make more progress because it means the countries who address what they have an issue with and not throw, don't throw the baby with the bathwater. So they will take in most of the provisions and then just express their reservations to the extent to which they wish to express their reservations. So basically, member states should communicate quickly on what provisions of an international instruments they have reservations on so that we can achieve a much wider ratification and domestication. The next one is the lack of effective monitoring of ratification and domestication of protocol. So the various ways in which the international agreements may be domesticated, which I indicated, makes it difficult to monitor or track when a state has domesticated an international agreement. It is easier where an international agreement has been domesticated in its entirety or where existing laws are substantially amended. But these instances are rare, as I have already stated. So common methods of domestication are those that involve the amendment of many laws that are impacted by a ratified international agreement. What is the recommendation? There's need for an effective monitoring system at national level to track the laws enacted that domesticate the SADC protocols, which already conform with the provisions of the SADC protocol, and also those which already conform with the provisions of the SADC protocols. Member states can accurately report on this in annual reports to SADC, and technical support can be rendered by SADC-PF at the request of a member state in that regard. Why have I emphasized the issue of at the request of a member state? You don't want to look as though you are now trying to be an overarching body and try to impose your agenda on the country. So it's good if these requests are made by the countries themselves. That way you are seen as a partner, as opposed to a big brother trying to monitor the internal affairs of your member states. So that approach, in my view, would be the most effective. So you have a mechanism in each of the member countries. Even reporting will be very easy at an annual basis. I think last time we were talking about the compendium, and we discovered that compendium was done many years ago. Ideally, we should have a compendium that can show the level of commitment of countries, if possible, every 1 year, at the end of the year, there should be a compendium to bring all the countries in check and also form the basis for interventions for the subsequent year. So that is what I would personally suggest. The next problem is the issue of the instance at the ministry responsible for the subject matter. As I explained again, if you're going to wait for a ministry to start the process, they may not have prioritized that particular instrument. They might be dealing with other issues and, these things may fall in the cracks. So the law mandates a ministry responsible for a subject matter to initiate the ratification and domestication, as we have already shown. So certain protocols may involve subject matter that cuts across various ministries and laws. This I had also stated. So there's need for a centralized system for initiation of the ratification and domestication of international instruments. What is that centralized system? Use the ministry responsible for foreign affairs. Let that ministry be the focal point ministry for all ratifications and domestications that involve international instruments. So the recommendation is that the initiation of ratification and domestication of international instruments should be done by the ministry responsible for foreign affairs in consultation with the ministry responsible for a subject matter. The sponsoring ministry for cabinet meetings and the process of enactment will still be the ministry responsible for the subject matter. It's just that this will make monitoring the ratification and domestication of international instruments easier, as information may be obtained from one point, which is the ministry responsible for foreign affairs. So that emphasis should be made as far as the domestication process is concerned. The next one is budgetary constraints. And I think this is very common for most jurisdictions because you're always dealing with a tight budget. So firstly, legislative process is costly. In fact, just running government generally is very costly. So the specific problems that we have as Zambia is that we have an inadequate number of drafters in the ministry responsible for justice, which is at the center of the ratification and domestication process. In the past, the Ministry of Justice has had to outsource drafters to draft bills, which was also costly because these are lawyers in private practice. So obviously, they will charge their rates for drafting. Internal legislative meetings and cabinet legislative meetings may have to be held out of station for many days, and this entails logistics and remuneration of officers, which is also a huge cost. The legislative process is at a cost and sits on the budget lines for the executive, for the individual ministries, and the legislative arm of government, not arms of government, arm of government. So the ultimate effect of the budgetary constraint is that the rate at which ratification and domestication of international agreements is achieved depends on the amount allocated for ratification and domestication processes within the government's fiscal year. So when you check the budget lines, and as you go back, members of parliament, check how much had been allocated towards the legislative processes. You will find that it's a very small budget, most likely falling under the Ministry of Justice and individual ministries. So there is need for better allocation for legislation. So the recommendation on this aspect is SADC-PF, at the request of a member state, again, I keep on emphasizing, at the request of a member state, provides technical support in identifying the laws that need to be amended to conform with SADC protocols and, where possible, avail drafting experts to ameliorate the shortage of experts in government departments of member states. This will not only directly benefit a member state in its ratification and domestic processes, but also increase the awareness and persuasiveness of the model laws drafted by SADC-PF in the best interest of the nationals of a member state. So you get involved where you are actually supporting a country in its legislative processes. Like I said, it will show a partner approach as opposed to a big brother approach in the process. Then some provisions of protocols may not pass the best interest test. This is the obvious one. So when an international agreement has been agreed upon at international level, the best interest test, which is the first test in the ratification process, has to be undertaken. There are certain treaties that may actually be counterproductive to the domestic needs of a particular country. And I gave an example on this particular aspect. So for instance, if one wants to achieve the free movement of people, goods, and services in the SADC region, remember that this is basically the agenda of the SADC system. This may conflict with the member states' policy on citizens' empowerment and promotion of local goods and services. In this regard, provisions of such a protocol may not be readily domesticated. So in that case, what does SADC-PF have to do? They should come up with model laws that strike a balance between the best interests of a member state on one hand and the regional integration and harmonization of legislation on the other hand. That way, countries will be more readily or more willing to domesticate. Now, the best possible solution, I think it was Mandela or some other leader who says the answer lies within. I always like to have solutions that can be found within where you are instead of looking outside. Now, I think as members of parliament, you don't realize how powerful you are, by the way. Within any government system, you know why you're the most powerful. You're the only ones who represent the voice of the people directly because you are elected by the people. The only reason why you sit in parliament in that chamber is that all the citizens of your country can't fit there. So when a member of parliament speaks, they are speaking the voice of the constituents. And when they, as a collective body, they begin to make decisions, they make decisions on behalf of the population. In fact, even the existence of the judiciary and the executive is dependent on what you decide in your laws for their existence. So that is where your power lies. Now, the solution that I would like to suggest actually lies in your two functions. One is the budgetary function. The moment the executive brings the budget to you, you have a certain level of control over maneuvering the allocation of funds. So next time you're in parliament and you're deciding, and it's good that we've had this meeting now. Most countries, I think, will be preparing their budgets in the next few months in preparation for the 2024 fiscal year. See how much is allocated to legislation or all activities and programs that revolve around ratification and domestication, and advocate for a larger amount so that it becomes very easy for the internal processes in your government to actually happen. The second one, which is the more exciting one, is your oversight function. How do you exercise your oversight function? Through questions and motions. So deliberately, as members of SADC-PF, you could actually raise questions to the executive, asking them. In fact, when you're talking about questions, you're asking them about the progress they would have made in ratifying the international instruments and domesticating. At that point, a minister has to respond and give government's position. And this is what we now have as government assurances, and later they'll have to come up with action taken reports. So that way it's easy to monitor where your government stands with regard to these international instruments. And if they had forgotten for any reason, you basically jack them up to say, look, we need to take this step. The next one is motions. I prefer motions in particular because they allow for more debate around some of these. So keep having motions to urge the government to ratify international instruments, either to do with the SADC protocol or any other that are beneficial to the country. So that tool you already have. Now I know that tool can either be effectively used when you're in the ruling party or when you're in the opposition, but it is available to both parties. For those that are in the ruling party, you even have the latitude to walk into the Minister of Foreign Affairs, the Minister of Foreign Affairs office, and say, look, we have this issue, can the government take care of it? Because maybe you may be skeptical about raising it on the floor of the House because it can cause embarrassment to the ruling party. So you can use the method of actually approaching the relevant ministers and asking them how far they have gone. So the budgetary function and the oversight function is your silver bullet as regards expediting the processes of ratification and domestication are concerned. So it's not up to the executive. You as MPs also have a role, not just to wait for those international agreements to come before you, but you can actually push the process by way of using your oversight functions. So those are some of the suggestions. I think these are some of the ones I've highlighted. So basically, in conclusion, I think the SADC-PF, and of course, I believe this would be more efficient if you are made a full-fledged parliament. But basically, the efficacy of the SADC protocols lies in their domestication by member states. Therefore, a rigorous exercise to ensure timely, not only timely, but appropriate domestication of the protocols is key to the realization of the objectives of SADC and regional integration. So the SADC PF presents great opportunities to achieve this because it's essentially a forum for members of parliament. Thank you for your attention. That's the end of my presentation.
Thank you very much. And looking at the time, it's 11:10. So we're going to have a 20 minutes break and then we're going to come in for the question and answer session. So we're going to resume the meeting at 11:30. We can go for break on members. Thank you.
Thank you.
Welcome back, honorable members. And now we're going to go into the interactions with our presenters. And first and foremost, let me thank all our three presenters who have given us some insightful information on as far as our different countries are operating. Basically, the wisdom behind the three presentations were also to say we should be able to benchmark to see which one is similar to our country and which one can we learn in terms of our best practices, so that we can become ambassadors in our respective state, in our respective parliaments, and try to lobby. So with a raise of hand, I'll identify the members, and then you can also either give the directive to say I'm asking in particular to presenter A or presenter B in as far as the question is concerned. So I see a hand from Botswana. You have the floor.
Thank you very much, Chair. Let me also express my sincere gratitude to the presenters from Eswatini, Angola, and Zambia. These were insightful presentations. I think we speaking for myself, I think I've learned a lot. My questions really are directed to all the presenters in terms of the oversight role of Parliament, particularly the adequacy of provision of oversight. What I've picked from the presentations is that there's a similarity in terms of the responsibility and power placed on executives to determine the best interest test. For instance, to say, as a country, should we? Is it in our best interest? It's like it's a responsibility that is initially placed at the executive. If, for instance, you look at the Botswana case, for instance, the executive power of Botswana vests in the president, subject to the provision of the Constitution at section 47(1) and 2. Now, even the decision to go to sign and ratify treaties, it's a prerogative of the executive. Now, what I think I have observed is the major difference between Botswana and Zambia is that in Zambia, the request has to be made from Parliament to say, can we go ahead and ratify? In our case, Parliament only gets in when there's decision to domesticate, which requires either a codified policy or enactment of a law or amendment of a law, whichever way. So now I'm a student of democracy. I believe in participatory democracy. I believe it's still possible. Maybe not in the Athenian sense during those times where participatory democracy was practiced. But if you look at how the UDF in South Africa was run, if you look at how the Swiss democracy is, I think we can get lessons on participatory democracy. Now, you made a good point that as Parliament, we're a barometer of public opinion. Whatever we say it because we are saying it on behalf of the people. But then my view is that perhaps we need to find a way in which Parliament can play a more meaningful role, even on the determination of best interest test, that at that level. Of course, there are other ways which are available in which we can play our part. We ask questions about treaties. why have we not ratified such and such a treaty? We have ratified, sorry, we have signed, but we have not ratified. We have ratified, but we have not domesticated. At times we have signed, ratified, domesticated, not implementing. So such questions do come in Parliament. And of course, there are motions. We have had a motion on I think by Honorable Lucas. Yes, yeah, on ratification of yes. So yes, Parliament does play that role. But for me, I think the Zambian case, I think it serves as a very good example to emulate, speaking for my country, where you actually go to Parliament and debate the pros and cons of ratification. But I think we can move a step further in terms of Parliament playing a more meaningful oversight role. Now, it takes me back to another question on some of the treaties. I don't know what the differentiating factor would be, but I think if you look at the Swiss, for instance, there are those treaties that will have to be subjected to a national referendum to say, for instance, they belonging to a particular international organization. The people have to say yes or no. And I'm thinking that perhaps in some instances, and I wouldn't pinpoint which instances because there are so many international treaties and protocols, but I think those that maybe can be determined to be of a very high policy and huge impact on the populace. We may also need to subject those to national debates, either by way of a referendum or just the general consultations that members of Parliament do. The other part, which I think it's a one aspect in which Parliament can also, play a more meaningful role is through its committees. It's through its committees, because you see, when you look at our standing orders in Botswana with committees, they sort of equate those to judicial proceedings. We can subpoena witnesses, call for evidence, papers, persons. So the power that MPs wields through committees, they can call in anybody and they can ask all manner of questions, and they can even determine how they go about pushing for reforms. So I think one way we have a committee responsible for foreign affairs. We have a committee responsible for subsidiary legislation, for standing orders and reform. And I think those are the committees that can, follow up on these issues to really, put Parliament in a position where it really determines the direction insofar as the determination of the best interest test, the decision to sign, the decision to ratify, and ultimately domesticate and implement. So I think committees also, play a very important role. But of course, the other way, besides questions, besides motions, besides private bills, if needs be, besides committees, is our general policy debates, especially when ministers of foreign affairs, present papers in Parliament, make statements, or even present budgets. Those are it provides us with opportunities to also, air our views. So the other question which perhaps the lawyers could assist us with here is the issue of the persuasive nature of the treaties versus the binding. I know, for instance, we have talked about if you could just give me a little moment here, Mr. Chairman. For instance, we have the Rome Statute. We have the Rome Statute establishing the International Criminal Court. And remember that the Americans then decided to go into bilateral agreements with several African countries not to surrender their law enforcement or civilian suspects who are indicted by the ICC. Now, the question that I want to ask the lawyers, in our jurisdiction, there is case law that international treaties and protocols, whether signed, ratified, or domesticated, they have a persuasive effect and not a binding effect. So I don't know what is the position is in other jurisdictions, and whether you can sign, ratify, domesticate, and actually be not bound by an international treaty. You know that some countries, which South Africa, for instance, they are signatory to the Rome Statute establishing the ICC. And they are very clear in terms of they didn't surrender al-Bashir to the ICC, even though he was indicted. They were not prepared to arrest and surrender Vladimir Putin. So I just want to know because South African courts are yet to determine the cases in terms of whether the state is actually obliged to arrest such individuals. So that's what I wanted to find out from you. Otherwise, these were wonderful presentations. Thank you, Mr. Chairman.
Thank you very much, Honorable, for the interventions. Do we have any other hand? I see the Vice Chairperson from Tanzania. You have the floor, Vice Chair.
Thank you very much, Honorable Chairperson. I think I should start by thanking all of them for their very good presentation, very educative and precise. Today has been a very good day for us, being parliamentarians and getting all this in a very well expressed manner and easy language. Now, I have few of requests to be elaborated. Starting with Eswatini, may I thank our learned sister, Thoko, for sharing with us the way it is done in Eswatini. But then I also have few pages, like in page 26, when she was talking of the protocols starting from the executive, and then she mentioned, it was on page 25, the king. I was a bit confused when he said executive and then the king. In my country, once you say the executive, it means the president and his team. And then we have the judiciary and the parliament. We are of those three arms. Now here in Eswatini, it's something different. If you may just assist when coming to wind up. Another thing from Eswatini, it was on recommendations. It was mentioned that the AG should be informed. Then I was thinking, who should inform the Attorney General? Because he's within there. He's one of the people who are doing it. It is on page 30. Maybe I just request there a bit of clarification. And while listing the team, how do I call it? While listing those in the protocol, I also discovered that the king came on the last list. I thought the king is how we feel it outside when it is a kingdom, say in my country. We think he's the leading, he's the one with the country. Having said that, I'm requesting Honorable, well, I don't want to mention the name, maybe I might forget, but the presenter from Angola. Thank you very much for the very good presentation, but there was a place I noted down. You say that while talking of the model laws, we, SADC, as a forum, we should know that we are just a forum, Then I was thinking, what would it have made any change if we were a parliament? Because right now we are on a stage of forum, then soon or after a few days, but we're making all those model laws, which I think, me personally, and maybe the rest of you, we are online. Now, what makes it inferior from whether we were parliament? Because I know being a forum is a stage heading to becoming a parliament. So I think you will assist me on that because it made me a bit, I don't know, I don't have the word, but I was, am I on the right track? Or maybe I didn't understand well. Are we on the right track as a SADC forum with our modules? Having said that, I am also, but I should also congratulate Angola because they've really done a number of them, domesticated, I think 2 or 3. May I now go to my learned brother from Zambia? Zambia, thank you very much. I could understand you very well. And may I say that today you have made me also not a bush lawyer, but a lawyer of a certain kind, though I cannot be a draftsman, but I know as a member of parliament what we are supposed, now I know what we are supposed to know. Oh, the rest, we should share the rest to our people. How I'm going to share it? Lucky enough, my speaker is a learned sister, very able, and she's a PhD holder. So I'll just tell her that your parliament is not really active enough on these things. How can we assist? I know she will understand me. She's a very able woman, and we are happy and proud of Dr. Tuliakson. So I'm just taking the ugali, what you taught me today, straight to her in a hot, plate. But now, as you are explaining this, you said so far, Zambia have domesticated only 2. I'm sorry. Just do a sign if I'm wrong. Before I kept on spoiling the matter. That is what I learned from you. Now I'm asking myself, is it not the right time now? And this is to SG, Madam SG, at least to have a table to see in SADC so far how many international treaties have been taken aboard. I mean, have been, not ratified, but have been introduced. How many in such and such a country have been ratified and put in shelf? How many have been ratified and domesticated? At least we can, I don't want to point fingers, but it is natural. Having said that, I just want to ask a question or a request for elaboration. after an international treaty being ratified by either member of the region, and then some carry on to domestication. Is there a way written that after, no, on presentation, it was mentioned that it's one's country wish whether to carry on to the stage of no ratification, yes, but domestication. Now, one thing I don't understand, with all those meetings and all those, a lot of emphasis, then it is rectified and put in shelf. Is there no time limit for domestication? And if not, if it goes like a popcorn, in case of any country decides, okay, we've rectified, we are going to domesticate this, again, another one, the same country, even 3 or 4, then will that country be running on its own? I need an elaboration from my learned brothers and sisters. Thank you so much, Honorable Chair. I present.
Thank you very much, Vice Chairperson. I see a hand from Seychelles. Just a single hand or two? Two. All right. So you have the floors. After that, and then.
Thank you, Mr. Chair. And I would also present my gratitude to the 3 presenters. And in the case of Seychelles, our system is mostly like Zambia. And like you were mentioning, those countries that were colonized by the English. So we've been using that same system. Of course, it's all based from our constitution. And the same line of the procedure through the Ministry of Foreign Affairs and with the minister responsible for the specific subjects. And then all the procedures are mostly the same in line with that. But I don't want to delay because others have spoken. In terms of course, in terms of oversight, we have the committees in the National Assemblies, the KOGA and the FPAC, which they provide oversights. And at the same time, they do not just provide oversight by calling the ministries in, but they do site visits as well to ensure that whatever the ministers have entered into the National Assembly, they go and verify whether they are what it should have been based on the money that was approved for the current ministries, and so on and so forth. And of course, I will agree with the challenges that you mentioned, which we are facing the same problem, though we are smaller than Zambia. And especially when it comes to the bottlenecks of implementation, because my sister was mentioning about the ratifying and domestication. So most of the time we do ratify, but domestications may be a hassle in terms of implementation. Because it needs sometimes to get a comprehensive framework within that certain ministries, or maybe it needs to be, there are different lines of ministries. Like, for example, if we take the GBV, it's the issues mainly nationally, it involves different ministries, like the Ministry of Family Affairs, the Ministry of Health, the Ministry of Defense, the police, the Ministry of Social Development. So it's a whole lot of a comprehensive involvement of different line of ministries. And of course, we have the NGOs as well. So to ensure that once being domesticated, you will find that probably the commencement date may not be feasible for us to say now we are going to start the implementing the framework or to domesticate the treaties or the conventions. And at the same time, I will do agree probably as countries in the SADC region, we can support, I don't know how best we can do it, but maybe we can, to ensure effective monitoring and to keep track on the protocols, what has been going on. I don't know how we're going to do it, but maybe we should find ways and means of devising a certain procedural protocols, terms of reference to see how the SADC region can monitor the protocols, the investigations of protocols, and for us to have an effective monitoring system. I don't know how the reporting is being done right now, but I know for other institutions, like how do we monitor the SDGs? How did we monitor the MDGs? How do we monitor the CEDAW strategies? Though there must be some means of devising the countries providing their inputs, how to monitor these tangible treaties, that it must be done within our country. And of course, like you mentioned, the processive legislation is very costly. And for a small country like Seychelles, the judiciary may not be feasible enough. They may not have the comprehensive resource that they will need in terms of manpower to ensure that we implement to support the domestication of the treaties. And of course, the other side is the technicalities, the technicians available to ensure that we monitor and at the same time we provide a comprehensive to the best interests of the people of Seychelles and the best interest of the country. So this is my contribution for Seychelles. Thank you very much.
Thank you very much. Yourself, the floor, Honorable.
Thank you, Mr. Chair. Just to add on, I will be very brief because I think she covered most of the point that I had. I just wanted to point out, I know when the presentation was being done for Eswatini, there was one slide, slide 29, that you say the recommended that a fully fledged unit be established to coordinate international instruments. I just wanted to point out that back in Seychelles, usually it's the Foreign Affairs Ministry that do the coordination. And when I was listening to the presentation from Zambia, when he mentioned that it's the Ministry of Justice that present the paper to cabinet. But in Seychelles, it's not we don't have a Ministry of Justice. Usually it's the Office of the Attorney General, the AG's office that deals with all these instruments, and they present it to the Cabinet of Ministers. And you said something about monitoring system at national level to follow up on these instruments. You know, sometimes one challenge that we have in Seychelles, there is no coordination between the Ministry of Foreign Affairs, the AG's office, and the Parliament. You see, we lack the coordination and the communications because sometimes it's difficult to know which treaty or which protocol has been deposited or has been signed, which need ratification. We sometimes are being left in the dark until it is presented to Parliament for ratification. I think we have to improve on this communication between the Parliament, the Executive, and the Ministry of Foreign Affairs, because most of the protocols are deposited at the Ministry of Foreign Affairs. And sometimes they are late to be sent to the AG's office to prepare the cabinet paper. This was my observation. Thank you.
Thank you very much. Do we have any other observation?
You.
No, for me, I think Malawi is very similar to Zambia. And I served in the Committee of Legal Affairs Committee from 2019. So most of the steps that he had mentioned, they are quite very, very true reflection of Malawi because it's exactly the same. It's just a matter of how best we can come up with the solutions to say, if we can cut some of the steps, as he had said, that it starts at the ministerial level and then it goes back to the ministerial level, and also the fact of budgeting. Because when we go through our budgeting, there's no enough money in as far as domestication and also drafting. Usually there's no money at all. So if there's no money, there's nothing we can do. But for me, the presentation from Zambia, it was a clear reflection of Malawi. But I also learned a few things from Eswatini and also from Angola. But I think the best approach is also to say, let's not be the big brother, as our colleague from Zambia has said, but let's be a partner, because we should not be seen to be interfering in the affairs. And then they shall start, the sovereignty comes in. But for me, I'm quite very convinced. And with Zambia, we are using exactly the same law. So I would give to the presenters. I think we can start with Eswatini, and then Angola, and then we finish with Zambia. Thank you.
Thank you, Honorable Chair. Thank you, Honorable Chair. On the issue of the roles of the executive and the king, our constitution provides for the three arms, and it provides that the three arms of government, the king is at the apex of the three arms. So he holds all the powers, executive, legislative, and judicial powers. So, but when it comes to the enactment of legislation, the king in parliament, as far as the constitution provides, it says it's a king in parliament who enact laws. So, simply put, the executive does the spade work, the negotiation of the treaties, and then when the treaty goes to parliament, the legislature looks into the treaty, and then at the end, after the instrument has been has passed through parliament, the king has to assent to the legislation. He has to sign that the legislation has now passed. So that's how the king features in the whole process. The honorable member noted that I mentioned the king at the end. Of course, at the beginning, the king is there when the protocols and the instruments are signed, because the king holds the executive powers as well. So he signs on behalf of the country. If it requires that the king signs, but sometimes the prime minister or the ministers sign, depending on the status of those international instruments. What's the other question from Zambia? AG should be informed, yes. The constitution provides that a treaty cannot be ratified without the advice of the Attorney General. But because, as we have mentioned, the executive or the technocrats are the ones that do the negotiation, and then the king, and then the Attorney General has to advise, but you find that the executive and the technocrats go to meetings and they do the negotiations and they do everything without even involving the Attorney General, as in the department that is tasked with international instruments. You find that only the legal advisors attend to the negotiations and the other meetings, But in most cases, you find that because of limited finances, most of the time you find that even the legal advisors, they do not attend the meetings where there are negotiations and where the treaty is finalized at the executive level, so that the office of the Attorney General is left behind, in the sense that the department that is supposed to advise, or the Attorney General, are approached only when there's a question of whether the treaty is self-executing or is technical, or all of those questions that the ministry now needs to be answered for purposes of taking the treaty forward. So what I found from the officer that I talked to, she said that in most cases, they come to them to ask something that they should have, established even before anything else happened to the processes that are supposed to be done in the treaty. So that's how they are left behind. So that's why I recommend that the AG's office should be involved even at the beginning, to avoid instances where there's a question that has to be answered urgently, and then they bring voluminous documents for the AG to look at quickly and advise, yet they have the background to that treaty. I hope I hope you understand, the honorable. Yes. Why does the king come at the end? Oh, I have already mentioned this one. And then there's a question on, yes, the other questions are directed to the forum, SADC Parliamentary Forum, Zambia, yes. I think that should be all on my side.
Muito obrigado, senhor presidente, senhores deputados, estimados colegas. Relativamente à questão colocada pelo senhor deputado do Botsuana, eu devo dizer que, de facto, hoje já não estamos naquela fase em que alguém dizia que eu sou o Estado sou eu, l'État c'est moi, I am the state. Já não estamos nessa fase e, por conseguinte, mesmo no domínio das relações internacionais, que classicamente era considerado como um território exclusivo do executivo, já se verifica um crescente envolvimento dos parlamentos. E isto ocorre não só na área dos tratados, mesmo também questões que têm a ver com a guerra e a paz. Os parlamentos têm uma palavra a dizer, como vocês sabem, questões que têm a ver com a nomeação de embaixadores, questões que têm a ver com empréstimos externos. Significa que vamos progressivamente assistindo a uma crescente parlamentarização das relações internacionais. E ainda bem que assim é, que os representantes legítimos dos nossos povos controlem e fiscalizem a ação dos executivos no plano internacional. O senhor deputado também referiu-se às chamadas ratificações tardias. Os Estados negociam os tratados, assinam e depois não ocorre o terceiro momento, que é o momento da ratificação, ou às vezes até da adesão. E o senhor deputado procura saber por que que isso acontece assim. É de facto frustrante, mas nós devemos procurar saber quais serão as causas deste fenômeno das ratificações tardias. E uma dessas causas já foi aqui identificada, que reside no facto de a ratificação, como foi dito aqui pelo próprio senhor deputado, ser um poder discricionário. Quem ratifica não é obrigado a fazê-lo, em regra. Portanto, o direito internacional dos tratados remete isso para o direito interno. E será o direito interno que vai definir quem terá essa competência para ratificar. Mas não existe internamente essa obrigatoriedade de se ratificar um tratado. E foi justo. E há também um outro motivo para essas ratificações tardias que tem a ver também, por vezes, com questões de natureza política, não é? Nós vimos o que aconteceu nos Estados Unidos, o presidente Woodrow Wilson foi um daqueles que mais se bateu no final da Primeira Guerra Mundial pela criação da Liga das Nações, mas todos sabemos que os Estados Unidos depois não se tornaram membros dessa Liga das Nações, justamente porque o Senado americano, que na altura era controlado pelos republicanos, não ratificou este importante tratado internacional. E talvez o facto dos Estados Unidos terem ficado fora tenha também contribuído para a falência dessa organização internacional. Quer dizer que, por vezes, temos um executivo controlado por uma força política e um legislativo controlado por outra força política, e se o processo de ratificação for misto, no sentido de envolver esses dois ramos do poder do Estado, pode haver um bloqueio, o que vai contribuir para uma ratificação tardia, ou até mesmo a não ratificação. Quanto ao Estatuto de Roma sobre o Tribunal Penal Internacional, de facto é uma questão pertinente que levanta. Estamos aqui na África do Sul e deu 12 exemplos, o caso do presidente al-Bashir e mais recentemente o caso do presidente Putin. E o Estatuto de Roma sobre o Tribunal Penal Internacional é claramente um tratado com características de hard law. É um tratado que é vinculativo aos Estados-parte. Logo, se algum Estado que não foi obrigado até a vincular-se a esse tratado, sendo parte dele, ele obriga-se a cumprir com as disposições desse tratado. É isso o que resulta, pelo menos, da Convenção de Viena sobre o Direito dos Tratados. A Convenção diz claramente que um Estado não pode invocar o seu direito interno como fundamento para não cumprir as normas de direito internacional, a menos que se trate de uma violação de uma norma de importância fundamental do seu direito interno. Relativamente às questões que foram colocadas pela senhora vice-presidente, eu apenas quis dizer, quanto devemos ter cuidado no uso da terminologia para não criarmos eventuais ruídos comunicacionais. Uma coisa é dizer lei modelo da SADC, outra coisa é dizer lei modelo do Fórum Parlamentar da SADC. Eu vou dar-vos um exemplo. Quando nós organizamos em Angola, na província do Lubango, acho que em 2014, uma assembleia plenária do Fórum Parlamentar da SADC, os meus colegas do protocolo, ao colocarem à disposição das várias bandeiras na sala, colocaram também a bandeira da SADC. E no início, logo no início da reunião do Comitê Executivo, a senhora Presidente do Parlamento do Lesoto, Motsamai, Toloi Motsamai, penso que é esse o nome correto, pediu um ponto de ordem para perguntar por que aquela bandeira da SADC estava ali a perfilar com as demais bandeiras dos Estados. Se o fórum ainda não se tinha transformado num parlamento da SADC, se nós ainda estávamos a almejar essa transformação. E pronto, o Comitê Executivo pediu que se retirasse aquela bandeira, tivemos de fazê-lo. Então, nós devemos chamar as coisas pelos seus devidos nomes, não é? Mas devo dizer que o futuro parlamento da SADC, pelo menos tal como está desenhado no protocolo que o vai criar, ele terá funções de assessoria, não terá funções legislativas, e dentre as várias funções que ele tem, se não me engano, está também essa função de aprovar leis modelos. E ali sim falaremos em leis modelos da SADC, não do Fórum Parlamentar da SADC, da SADC, porque o Fórum Parlamentar, aliás, o Parlamento da SADC já será um dos principais órgãos da SADC. Relativamente à questão sobre se existe ou não um prazo para domesticação de tratados, a resposta é não, porque, como já dissemos antes, a competência para ratificar é uma prerrogativa do órgão competente do Estado, não existe essa obrigatoriedade, em princípio, para ratificar, e os tratados internacionais também não fixam um prazo para que os Estados adotem as medidas legislativas necessárias para a sua internalização. Mas é óbvio que um tratado internacional, todavia, só tem mesmo eficácia jurídica, senhores deputados, se internamente ele for acolhido. E é por isso que essa questão da domesticação é de facto importante. Nem todos os tratados são os chamados self-executing treaties, os tratados perfeitos, porque alguns carecem mesmo de domesticação. Aliás, o facto de se ser parte de um tratado, senhores deputados, resulta daí também a obrigação de aprovar essa legislação necessária para tornar eficaz esse tratado. Relativamente à questão colocada pela senhora deputada das Seychelles sobre os mecanismos de implementação de tratados, de facto, há tratados que têm mecanismos próprios de implementação, de monitorização, foi o que a deputada dizia, monitorização. Há tratados que têm sistemas próprios de monitorização. Isso ocorre, sobretudo, no domínio dos direitos humanos, no domínio da segurança internacional, no domínio da energia atômica. Nós vemos que são criados mecanismos de monitorização para certificar se de facto as disposições do tratado estão ou não a ser aprovadas pelos Estados-partes. Eu concordo plenamente com o que a senhora deputada disse relativamente à necessidade de uma melhor coordenação entre os atores internos do processo de conclusão de tratados. É importante isso. Essa coordenação entre o executivo, o legislativo, é muito importante, porque o tratado impõe obrigações e, do ponto de vista do direito internacional, a responsabilidade pelo não cumprimento de um tratado é do Estado. Não é do Parlamento, ou do Executivo, ou do governo municipal, não, é do Estado. Então, essa coordenação é, de facto, muito importante. Penso que são essas as questões que me foram colocadas e muito obrigado pela vossa atenção.
Please put the mic on.
Thank you. So I think the first was the honorable member for Botswana who added two more methods of pursuing for ratification, which is a committee system and general policy debates. I totally agree with that. In fact, committees is where the real work of parliament happens. So the only comment I would like to make on the committee system is that it depends on the country, or rather the committee clerks putting topics, because usually have program of work of a committee. So what's important is that a committee which deals the portfolio of foreign affairs should have within its program of work activities that go around checking how far the country has gone with regards to ratifications. And then through their report, then urge the government, or through its recommendations in the House, urge the government to actually ratify. And that aspect, I think, is the one that was dealt with also from some Seychelles. So the committee system has to be active, but it has to make it its agenda to do that, because most of parliamentary work, admittedly, happens at committee level. For general policy debates, these are very key, especially when you are looking at the budgetary role of parliament at the end of the year, when you're now looking at different heads and allocations of resources. At that point, this debate becomes absolutely necessary, because then that is when you begin to ask the key questions of why have you allocated this amount for this activity when it should have been more, or is it adequate? So at that point, you get the view of the executive as far as where they stand with the ratification process for the next fiscal year. So I thought I should comment on that one. So those two actually should be added as the two of the most effective ways. So basically we have 4 now. So I suggested 2 plus the 2 that you have added. This makes it a complete recommendation. Then the persuasive value of international agreements and effect of non-compliance. If I can put it in a very interesting way, when you agree at international level, this is what we are now calling soft law. It's really about the committee. It's a gentleman's agreement, the commitment of a country, but there's no real bearing in terms of the consequences of not following. That is why it's called soft law. In fact, domestication is what makes soft law hard law. The ultimate goal of soft law is that there should eventually be hard law which can actually be enforceable and justiciable at national level. So if you go halfway and just ratify, it's like a homeless man building a house and not living there. What have you done? The idea of building the house is so you can live there. So if you're going to build a house and then remain sitting outside, then it means you haven't achieved anything. So the true value of the international instruments is in their domestication. That's why this agenda has to be pushed. And this is now after the examples you've given, where if a country doesn't follow through, it can just, because it can just create a situation where it's frowned upon. What it has done is frowned upon by the international community, but there's no real sanction for most of the international agreements. So the persuasive value of international agreements is actually seen in another sphere. If the High Court or the Superior Courts are deciding on a matter and there is not sufficient national law on the subject, for purposes of helping them come up with a just decision, they can look into international instruments for their persuasive value. So persuasive in that they are not bound as the courts to follow what is written in the text of the international agreement, but it can aid them in dealing with a national matter which has arisen, and that is the extent to which it is persuasive value. So for now, even for model laws and what is done at SADC PF level, it will be persuasive. But the key or the ultimate goal, I do believe, is to have these model laws and their progressive provisions be found in the national legislation of the member countries. At that point, we would have said we've achieved something. Then another aspect I had picked was on domestication. So I needed to confirm something. The honorable member for Tanzania had said Zambia has only ratified 2. So I just thought I should provide clarity. So the context in which I mentioned the 2 is that these are the only international agreements we have domesticated in their entirety. Otherwise, Zambia has made a lot of progress. I think ZDPF, the SADC can check. We've ratified quite a number of protocols and we've actually domesticated quite a number. So I think the context in which I mentioned that was the fact that the styles of how you domesticate are very different. And I think at this point, I should also appreciate the comment from the honorable member from Seychelles to say part of the explanation for the delay in the ratification is that these some topics or subject matter cut across different ministries and different angles. So that is definitely the position even in Zambia, and I totally appreciate that. It's the fact that there are so many things you need to put in place and there are so many players, so it's not easy to just do it within a short period of time. There's need to check your policy frameworks, check the system and whether or not it fits in. How do you then not domesticate? How do you then customize the international agreement into your own legal system? So all that has to happen, and it could explain why there have been some delays in ratification. So for Malawi, yes, we share a lot in terms of our history. So it's no surprise that our laws are very similar. Seychelles, it's very interesting to note that we also have very similar problems. And I think the issue of the coordination, Zambia has done a good job on this one, maybe because I think the Attorney General is always involved, either at the point of ratification and also at the point of domestication. So they are very central. And so they are a repository of information, both from the ratification end and are also involved using their drafting department on the part for legislation. So then the Seychelles had also talked about the monitoring mechanism. I think that's something SADC really has to seriously look into, so that even when we are making suggestions, which I'm positing should be country specific, we know exactly what is happening in that country by the time we're looking at interventions. So the progress made by Malawi may not be the same as the progress made by Tanzania. So we need to be alive to some of these differences and the different paces, and also the socio-economic situation of these countries in order to properly understand how or when to intervene as far as the domestication process is concerned. So those are the aspects I thought I should comment on arising from the members' questions. Thank you very much.
Thank you very much. I think there's another small question from the Vice Chair. Vice Chair, you have the floor.
Thank you, Honorable Chair, and thank you all presenters. I'm just asking one question, maybe I'm curious. Is there any best practice internationally of the trend of rectifying, domesticating, and customizing as well? Do we have any thing in heart or in mind of having a best practice?
Thank you. Before you check that one, I saw a hand from Seychelles as well. You have the floor, Honorable.
Thank you, Mr. Chair. I just wanted to make a small contribution while I was listening to the Honorable from Zambia. I think maybe on the issue of monitoring. In Parliament, we have a committee known as the International Affairs Committee. I was thinking maybe this committee should be the liaison from Parliament to the Ministry of Foreign Affairs in regards to these international instruments. Maybe we should go back home and liaise with the International Affairs Committee, and they be given the mandate to be the liaison, so that we would know when a treaty or protocol has been deposited. Okay, thank you.
You have the floor, Honorable.
Question, not a question, but a clarification. In regards to when Zambia was mentioning about having soft laws can become hard laws. Can you probably specify, and especially in the case for the small island states like Seychelles, climate change, is it soft laws, treaties that have been signed? And yet why I'm saying it's because the big countries, they tend to sort of ensure that climate change becomes an issue whereby the small island states has to abide to them, but at the same time, they are not providing the support that the small island states or other countries needs to ensure that the ozone layer are being protected and the seabeds are being protected. And is it one of the soft laws that you are talking about? It may become a hard law. Thank you.
Thank you very much. Any other intervention? All right, say hand from Botswana.
Just a comment to honorable members to say, I think we need to reclaim our place in terms of providing effective oversight when it comes to the decision to enter into treaties, to sign them, to ratify, to domesticate and implement through various ways that we have discussed. But most importantly, I think the point I want to make, Chair, is that you see, most of these treaties and protocols, when you scrutinize them, they're actually a vehicle towards democratization at the end of the day. And sometimes you may find that there are, political decisions in terms of whether to move forward along the democratization continuum or to halt or even to regress. The point I'm making, Chair, is that, you see, in some instances, it's very clear that the signing, ratification, domestication, and implementation would result in some instances, those in power losing that power. The example that one can make is the SADC protocol on the SADC guidelines on elections, the SADC PF model law on elections. Some of the governments, if they can adhere to the latter, to those instruments, they will be out of government. So sometimes let's not think that the decision not to sign, ratify, domesticate, and implement are basically about anything. They're just basically about self-preservation in some cases. I think we can go on and on with this debate, but I think my view is that most, if not all, of these international treaties and protocols are basically, at the end of the day, about democratization, the process of democratization, moving further and towards democratic consolidation, which is where ideally we should be going, democratic consolidation, where we have strong democratic institutions that are responsive to the people's needs. That's exactly, that ought to be the quest, democratic consolidation. So yeah, DG 16, yeah. So that's the 2 cent comment that I wanted to make, Chair. Thank you very much.
Thank you very much, Honorable. I think I'll give the floor to, I think the questions were directed to our counsel from Zambia. You have the floor, counsel.
So the first one is whether we have any best practice on domestication and implementation. Now, if you asked me, my personal opinion would be that all of us should be monist, so that by the time you are agreeing to an international agreement, it should immediately be applicable as though it was promulgated by your local parliament. That would be the ideal situation, because that way you are not looking at any other stages. But because we all have, the countries have different political backgrounds and legal systems, that's why this particular method cannot be generally accepted. So to be very honest, there is no best practice, because all practices are based on the political history of that particular country and their legal system. And that is why we are now saying, even whether you're monist or dualist, it would be good if there were timelines put, because see, when you put your timelines in the law, every stage has got an indication as to how many days it should take. Right now, and in all fairness, I'll give you this example. If you look at the processes we described about Zambia, there are about 9 stages. From the time that the best interest test is done by a minister to the time when it becomes law. 9 stages. Now, streamlining would be very helpful. But can you imagine if we had the 9 stages and we put a time frame to those stages within our own laws? That, in my view, would be helpful, because you can predict the fact that the moment the best interest test is done, Cabinet has got a time frame within which to consider that particular instrument. Parliament also has time frame within which to initially agree that the country should ratify. But as it is now, Cabinet has got its own agenda and also how often it meets. It has other business to deal with. In all fairness, it's not just ratification. It has all other aspects to deal with. So the ratification has to find its way within the program of Cabinet. So if this week it's not heard, it has to be next week. So even the technocrats and the ministries have to check for space within Cabinet's program. When it comes to Parliament, again, it matters at which point it gets to Parliament. Is the House on recess? Because Parliament also has fixed times within which it sits. In fact, if you split the meetings, and I think this is the case also with other countries. If you look at the Zambian system, we have the budget meeting from September to December. You have the legislation meeting from February to about April. Then you have the reports meeting, which is June, July. So strictly speaking, the only window you really have where you can do a rigorous exercise is during the legislation meeting, which is basically preserved for dealing with legislation. So again, that particular ratification has to now fit within the program of Parliament again. So it's a situation where we have not placed timelines. For me, the timeline issue should be good, but you know where that should sit? It should sit in the national legislation. If national legislation can prescribe within the laws, for instance, I'll give an example of Zambia. The constitution has already described the framework. Then you have the actual act that gives you each of the stages. If it can be agreed that timeline should be put for every stage which has already been identified, that would really help in expediting the pace at which, once the country has committed itself at national level, that should now find itself sitting on the statute books and therefore enforceable and justiciable by its citizens. So that would be my comment on that particular one. On the committee responsible for foreign affairs, that's actually a very progressive suggestion. So the same way we are saying there should be a centralized system in the executive where the Ministry of Foreign Affairs should be the one to coordinate the ratification process in collaboration with the ministries concerned with the subject matter. I would argue that by the same extension, let the committee responsible for foreign affairs on the parliamentary side be the one to check the progress made by the executive in ensuring that those international agreements come at the 2 stages they do, which is the first one before ratification and the second one at the point of domestication. Then we'll get someone. So that would be my suggestion on that one, because as my brother from Angola had mentioned, it becomes tricky to put a time frame at the international sphere, because each of the countries have their own laws and processes that they follow to achieve the domestication. So then the answer to that would be, why not put within the legislation of the country time frames so that it becomes predictable? So even SADC PF can say, Zambia, how come you haven't kept to your legislative processes according to your law? It's easier that way than to try and enforce soft law, which is at international level. Now, the last comment I'll make is the issue of climate change and the issue of soft law. So essentially, when you agree at international level, which is now what we call the soft law, and I understand the climate issue, by the way, I'm actually a student of environmental law at UCT. So it's something very close to my heart. And I do know that the islands are very particular about that because they are adversely affected by climate change, like all of us, but more particularly, their conservation schemes are much more rigorous, in my view. Mauritius and Seychelles in particular are very particular about nature and climate change. So right now, we have standards at international level, which we're now calling soft law. There's nothing stopping Seychelles from adopting the standards at international level and putting those standards into their laws on environmental management, either as a process when you are for development planning, or a certain minimum in terms of how you use resources within the country. At the point when you get the international standards and make them part of your law so that they are justiciable and enforceable, you have turned what is soft law into hard law. whereby all the parties, including the government, have to adhere to the standards they would have created for themselves under your law. So at international scale, that is soft law. But it's up to you as parliamentarians to get those standards and put them into your environmental management laws so that they're enforceable and justiciable, in which case now there'll be hard laws. So hard laws, there's no choice about following. There's no choice about enforcement. There's no choice about compliance. So that's why we are saying the ultimate goal of the soft law is that it should eventually find itself as hard law, which is enforceable and justiciable. And I think that is what SADC PF is pushing, to make sure all the model laws, which are reflective of the contemporary practices, they should now be reduced to actual legislation, which is enforceable. So that is where we need to go to. So Seychelles can move soft law into hard law based on your normal legislative processes. Thank you, Chair.
Thank you very much. There's an intervention from Angola.
Muito obrigado, Sr. Presidente. Eu também gostaria de adicionar mais algo àquilo que foi dito pelo meu colega. Começando pelas boas práticas, ou melhores práticas relativamente às leis modelos, eu acho que é importante salientar que as leis modelos não são uma invenção do Fórum Parlamentar da SADC. Portanto, outras organizações, outras instituições também têm essa prática de aprovação de leis modelos. Se calhar, a instituição no sistema das Nações Unidas que mais avanço tem em matéria de aprovação de leis modelos é o ANCITRAL, que é a Comissão das Nações Unidas sobre Direito do Comércio Internacional. Portanto, tem um conjunto de leis modelos neste domínio do comércio internacional, que tem também esse caráter de soft law e que tem sido uma boa referência para os Estados. Quanto à questão da senhora deputada das Seychelles, relativamente ao soft law, se calhar seria bom nós também percebermos qual é a razão da existência desse soft law. Se temos instrumentos jurídicos internacionais que são vinculativos, têm o caráter de hard law, por que é que os Estados também escolhem legislar por via do soft law? E a resposta está relacionada com a forma como está estruturado o sistema internacional. Como os senhores deputados sabem, no sistema internacional, nenhum Estado se subordina ao outro. Os Estados são soberanos no plano interno e independentes no plano externo. Então, o processo legislativo internacional é resultado de consensos entre os Estados. E vocês imaginam que mesmo ao nível dos parlamentos, às vezes é difícil chegar a um consenso para aprovar uma lei. Agora, imaginem no plano internacional, 194 Estados, por exemplo, ou 16, aqui na SADC, ou 54 ou 55 na União Africana. Cada Estado zela pelos seus interesses nacionais. Chegar a um consenso nem sempre é fácil. Sobretudo em questões sensíveis como direitos humanos, ambiente, questões de boa governação corporativa. Então, é nessas áreas em que o consenso é difícil, os Estados optam em legislar por via do soft law, porque sabem que esse instrumento não é vinculativo, então legislam por essa via Mas obviamente que com o tempo, se as condições forem adequadas, aquilo que era soft law pode se transformar em hard law. E nós temos um exemplo concreto aqui na SADC, em matéria do género. A SADC tinha aprovado, em 1997, em Blantyre, no Malawi, a chamada Declaração da SADC sobre Gênero e Desenvolvimento. Esta declaração, que até estabelecia o princípio, a cota de 30% nos cargos de direção e chefia, era claramente soft law. Muitos dos nossos países não alcançaram essa cota de 30% e não foram responsabilizados por isso. Por quê? Porque era soft law. E foi justamente por isso que a própria SADC percebeu que era preciso passar esta declaração para um novo estágio e foi aprovado depois o protocolo da SADC sobre gênero e desenvolvimento. Esse protocolo já é hard law, já não é soft law. Eu não sei se o protocolo já está em vigor, eu sei que depois foi emendado por um acordo, não sei se já está em vigor, mas aqui estamos perante um instrumento que já tem a mesma característica de hard law. Reparem que os instrumentos que são soft law geralmente têm a forma de declarações, não vamos encontrar neles quaisquer disposições sobre a entrada em vigor, como acontece nos tratados. Então, essa é a razão. Às vezes, devido às divergências, à falta de consenso entre os Estados, o soft law é uma forma muito conveniente de legislar no plano internacional. Portanto, esta é apenas uma explicação adicional àquilo que foi dito pelo meu colega. Okay, muito obrigado. Em relação do Sr. Deputado Bolsonaro, eu concordo inteiramente com o que disse. Os senhores deputados, de facto, têm que reclamar o seu papel. Eu concordo perfeitamente. Okay, muito obrigado.
Thank you very much. Honourable members, do we have any other interventions? Thank you very much. And having come this far, I would like to invite the Secretary General to give us her closing remarks as we're about to wind up.
The closing only belongs to the chair. So anyway, Chair, thank you very much. And honorable members, let's give a round of applause to our parliamentary staff. I think they've done justice to this particular intervention. And just to say that, you know, as the head of the Secretariat, I've registered your engagements from yesterday, the interventions that you have made yesterday and today. And I believe that you'll agree with me that they've enlightened us on the status of the implementation of protocols and how they contribute to regionalism, to democracy, as some of the members have said. And we've also looked at the similarities with model laws. So that was the intention when we put together this program. And I believe that those have catalyzed issues for us to consider. I want to believe that we've been further enriched by the interventions from Angola and Eswatini and Zambia. I think the staff have shared, you know, very genuine perspectives on impediments in the domestication of protocols. And this has generated further information, which would enable this August committee to further strategize in delivering its mandates. From the SADC Parliamentary Forum Secretariat, let me just for the record thank the three parliamentary staff and the clerk of the National Assemblies who have made it possible for them to be in these meetings, because these interventions that they have made brings to the fore the issues around model laws, and also has shown us that these are not uniformly perceived across the SADC member states, including by those who have to do the work that is related to ensuring that these model laws are understood and interpreted in various jurisdictions. They've also exposed the fact that some model laws are quick to be tabled and engaged with, debated on, motions surface, while others, it would appear they may have difficulties appreciating their value as compared to treaties and SADC protocols. And I think this is an area that this committee needs to reflect on in terms of its functions, and also to address such shortages in understanding the model law making and assisting countries to make the best use of them, as in my view, they also hold persuasive value. And the intention was precisely to have these as guidelines and yardsticks that can be used in other form. It's also important, honorable members, to note that when you look at our model laws, they have explanatory notes, they have a preamble. And any concern whether this will create a big brother syndrome or create sovereign related concerns can be debunked if you read the preamble and the explanatory notes. So it's also important, I think, at this level for the forum to reflect, this committee to reflect further on how you can open avenues that are available to the committee and to the SADC Secretariat on how we can really look at this domestication of protocols, because we need to work very closely with the SADC institutions. Where I sit, the SADC Parliamentary Forum is part of the institutional framework of SADC, and therefore, that is why the Constitution restates that issue. But we need to identify synergies which may accrue when countries attempt to domesticate protocols using the model laws as catalysts. I believe, honorable members, you've heard that we say that the SADC model laws are not coming from without. They are amplifying what already exists, but our focus here is to ensure that members also can utilize it. So the takeaway that I take for the Secretariat, that will chart a way out to assist members to really understand the ins and outs and the four corners of domestication. In our meeting 2 days ago, I don't know if it's 2 days or 3 days ago, with the Committee of Clerks, they motivated for bringing back the Parliamentary Leadership Center so that the capacity development is much more tailored, and that the issues that are of priority can then be delivered from that modality. So I believe that this is one of the areas that we can look at. And I think it will also assist us in closing the gap between international law and national law, which has been recognized as one of the biggest challenges of the 21st century. I want to share something just to, that I shared with the Judges Forum not long ago. And I want to quote so that I don't neutralize what I delivered. And I'm sure it's a takeaway that you will also reflect on. It captures some of what you've been talking about. And let me quote, I indicated to the judges that it's important to mention to them that the model laws can also serve to prevent possible conflicts between the judiciary and parliament, whereby the judiciary as an independent institution strikes down laws made by parliament, which are deemed unconstitutional or which do not follow from good governance of the nation. There are robust judicial precedents to this effect within the SADC member states, especially as most states are vested with a constitution which establishes parliament and sets the parameters in which lawmaking can be conducted. I indicated that such invalidation of laws by constitutional courts are nonetheless unhealthy for a democracy, as it leads to unpredictability and casts a shadow of doubt over the sovereignty of parliament and its legitimacy within the context of the separation of powers. I appealed that since model laws are benchmarks, which are prepared by reference to international human rights treaties and covenants, they constitute reliable guides for legislatures to rely upon, thus ensuring that the laws survive parliamentary adoption and pass the judicial test if ever the law is to be contested in the court system. This is what the committee needs to look at: compliance with model laws, compliance with best practices across the board. With these words, Chair, I would like to thank you for leading us to where we are, for your leadership, and also thank honorable members for their participation. This value will not go unnoticed. We will integrate this into our work plan of this committee and make sure that the various committees also integrate the various elements of what emanated from here today. I thank you, Chair, and we remain committed to serve.
Honorable members, on behalf of the honorable members, let me thank you, SG, for the remarks. And honorable members, the Secretary General for the SADC Parliamentary Forum, esteemed presenters, staff of the SADC Parliamentary Forum, staff of national parliaments, distinguished colleagues and participants, ladies and gentlemen. From the outset, allow me to pay particular tribute to the esteemed presenters for their well-researched, informative, and timely presentations. Not only have they enlightened us about the challenges and bottlenecks in the ratification of the SADC protocols at regional and national level, but they have also reminded us that all is not lost and that we can make use of and accelerate our ratification and domestication processes as provided for in national constitutions and national laws, and ensure the implementation of the norms and standards in order to address issues of mutual interest using harmonized legal norms. One must, however, commend the initiative taken by the forum in seeing the need for addressing the slow pace of ratification of the SADC protocols and in taking the initiative with the assistance of cooperation partners such as the SRHR project to organize the meeting to deliberate on the issues at hand. In order to forge a way forward in ensuring the ratification of the SADC protocols and to enable the committee to develop strategies for its initiative and to put together recommendations in a form of a resolution to plenary. Let me further extend our appreciation that not only have the presenters pointed out challenges in the issues raised, but they have also offered possible strategies for the ratification of the protocols and domestication of their provisions. Their presentations have also helped identify and provide clarity on the relationship between the critical areas of ratification and domestication, around which we can strategically focus going forward in our mission to monitor the domestication of our model laws. You will agree with me, honorable members, that our interaction with the presenters has thrown a challenge to us as parliamentarians to be more robust in identifying the legislative synergies that exist between SADC protocols and model laws, especially where there are mutual supporting thematic content across the instruments in undertaking our oversight role on the critical and urgent issues addressed in the SADC model laws. The engagement today has also encouraged us to actively participate in domestication initiatives in our respective countries. It has also shed light on areas of ratification and domestication in which we need to pay particular attention as legislators as we execute our mandate. Honorable members, the SADC protocols and SADC model laws are key instruments that will transform the SADC community in the African region. I wish to implore you, honorable members, to advocate and support amendments to key legislations in their respective jurisdictions in order to reinforce the domestic legal framework to accelerate ratification of the SADC protocols and domestication of the SADC model laws. I remain confident that honorable members will utilize the information acquired to diligently serve the SADC citizenry by prioritizing the issues covered in the meeting to address ratification and domestication challenges in their administrative processes, national policies, and laws. At this juncture, let me seize this opportunity to extend my sincere gratitude to all honorable members present here for taking time from other equally important assignments to attend to this meeting. A word of thanks also for the active participation, valuable interventions, and contributions that each member has made throughout our deliberations. Without your participation, honorable members, the committee would not have made the progress that has been made today. In other words, we have been able to successfully deliberate on matters of importance to our region only because each one of you, honorable members, was committed to the cause and you made the presence count. The positive outcome is the fruit of your hard work. Ladies and gentlemen, as I conclude, permit me to thank all those who have worked tirelessly to make this meeting a success, particularly the unsung heroes, our Secretary General and her staff. Thank you, Madam Secretary General, for your commitment and hard work. I also wish to thank all partners who continue to support us in various ways, including the sponsorship of the meeting and the presenters for today. Without your support, our work would have been that much of a difficult. With these few remarks, I thank you and I declare the meeting closed. Thank you very much, honorable members.
Yes. Thank you, thank you. Yes, no, lunch is served at the same place that we had breakfast this morning. And I believe that you're all well aware of your travel arrangements. If not, we'll send a message in the group to make sure that it's clarified. Oh yeah, I've been requested we should take a group picture. May we kindly go to the 8th floor by the pool area and we can take a picture there. Thank you for that reminder. Thank you. 8th floor, up. Before we transition to lunch, I think that would be quite helpful. Yes, yes. We forgot about Princess. Boarding passes, honorable members, may you kindly deposit your boarding passes to Ms. Toko. Yes. Boarding passes, we need that to show that you flew into South Africa. Yes. We need your boarding passes. Okay. All right.